All right, let's get on the record. This is 24CV003428. Clayton et al. Versus Lenox Green and American Family Insurance. Well, why don't we figure out who is here for what? And then I need to ask you about who's participating in takedown, and then we'll dive into it. Mr. Kaufman, I know you are here on behalf of plaintiffs. Good morning.
Good morning.
It's been a minute.
I think a whole month or two.
It's nice having you here, not talking about tabulating anything, but it's porches and balconies and liability.
We're not tabulating, we're not certifying it.
All right, good.
See you, Judge.
Same. And who do you have with you?
Christian Zim.
Good morning.
Hey, Mr. Zim, good to see you again.
Good. How are you?
I am all right. So we've got Kaufman and Zim. And on behalf of Lenox Green.
Mike Stacy, Your Honor.
Hey, Mr. Stacy. And finally, on behalf of American Family Insurance.
Good morning, Your Honor. Tim Wooten, here on behalf of American Family Insurance.
Thank you for being here. All right, so let me, first takedown. I don't know who invited the court reporter here. Is there any party not participating in takedown?
We're not.
You're not?
It's Lenox Green.
And American Family's not either. Your Honor.
Okay, well then it's the plaintiffs. There we go. Let me tell you what I think we're covering today, and then you all can say, nope, it's more or less, or we've settled. There is a motion to dismiss for failure to state a claim filed by Lenox Green, so Mr. Stacy and company, saying these claims need to go away. There is also a motion for summary judgment that American Family has filed. As I understand the nature of the relationships, plaintiffs are all condo owners at Lenox Green. Lenox Green is the condominium association, and American Family is the insurer, I'm not making a legal finding here, but it's not the individual insurer for each of the plaintiffs. It is in fact Lenox Green's insurer. And the plaintiffs are saying, Lenox Green, you should have ought to, maybe you did, reach out to American Family to get coverage for all the water damage and other things that happen to our condominiums because of these faulty balconies and patios and the roof. But American Family doesn't have a direct customer insurer relationship with any of the plaintiffs. It's 1 degree removed. And so American Family is saying, we shouldn't be in this at all. That's the motion for summary judgment. Cut us out. They're really only in, I think, the declaratory judgment and bad faith claims anyway. All the others, breach of contract, negligence, et cetera, are plaintiffs versus Lenox. But I think those are the two motions that we're here to work through. So first question, Mr. Kaufman or Mr. Zim, and who will be the primary spokesperson? Do you agree that those are the motions we're dealing with?
Yes, Your Honor.
Okay, and you had a claim that I think you withdrew in your first amended complaint, or you've withdrawn in some respect that moots, I think, one piece of what we were going to work through. Is that correct?
Correct. Claim 3, the detrimental reliance claim.
Okay. And then do you agree, Mr. Stacy, that's what we're working through today?
I do, Your Honor, with a proviso. When the amended complaint was filed, there was a motion for judgment on the pleadings filed as the now withdrawn detrimental reliance claim, but also it said the arguments in the motion to dismiss apply equally to the amended complaint. So to the extent that there needs to be something to carry forward that motion to dismiss to apply to the amended complaint, it's technically still live, but it's not really something that we have to argue separately. Okay.
While I've got you, one of the arguments you made, and we can dive deeper into it, I just want to know what I can push to the side and not worry about in the motion to dismiss, was that the plaintiffs hadn't complied with this condition precedent in the declaration of meeting with the board. And I think as things have evolved, it's been brought into the record that in fact the plaintiffs did meet with the board, and the timing may be significant. We can talk about that, but am I correct in saying that that's not really anymore a basis upon which you can rely to dismiss the complaint because the plaintiffs failed to meet with the board?
Correct, Your Honor. We're not going to pursue that argument at this point, on a motion to dismiss.
Okay, great. And then Mr. Wooten, you agree that your participation today, I won't say limited, you can chime in whenever, but your focus is your motion for summary judgment that just deals with the declaratory judgment claim, not the bad faith, but that the deck action should be resolved in your favor.
To some extent, Your Honor, the bad faith claim was added after my client filed for summary judgment. Not here to actually argue that now. However, I do think that the grounds for a bad faith claim are similar, if not parallel, to what the standing issue is to assert the declaratory judgment action. So if it can all be wrapped up here today, that'd be great. But again, it's wasn't part of our motion initially.
Okay.
Filed afterwards. Got it.
Okay, helpful. Then why don't we get into it? I guess let's start with Mr. Wooten. I think the smaller, more discrete issue is what basis, if any, do the plaintiffs have to bring claims against American Family? And so I guess it's at least twofold. It's the standing. Is there even a basis to be suing American Family? And then assuming there is this an appropriate declaratory judgment action? It strikes me as one that would, we're one step removed from that. And frankly, and this sort of is where the two issues merge, it would be Lenox that would be, if found liable, would be saying, wait a minute, we got to drag American Family in here. And then we'd see the classic, well, we first need a finding of duty to cover. Are we even responsible for the things that Lenox is responsible to the members of the association? And it may be that I find that the plaintiffs have tried to compress all that into one, and American Family shouldn't be required to litigate at this juncture because it's too soon in this liability process. So having said that, not having made those decisions, but just sort of encapsulating your argument, Mr. Wooten, why don't you get us started by sharing your views as to the motion for summary judgment. Then I'll hear from Mr. Kaufman on that. And if Mr. Stacy has anything he wants to say about it, he can. But again, it's not really his fish that's being fried in that motion.
Thank you, Your Honor. You've pretty much stated my argument I was going to make for you here, encapsulated here. May it please the court. As Your Honor just stated, there's two issues to this. One is whether the plaintiffs have standing to assert this declaratory judgment, and somewhat relatedly, the bad faith claim. But also,
I'm going to interrupt you for a sec, and it may be, I save this, I come back to it for Mr. Kaufman. The declaratory judgment ground or claim seem like it's actually two pieces. One is declare that Lenox is liable, which seems like that's what the fact finder will do at the end. But setting that aside, that's really not anything you are about. And the other is why you are here, which is and declare that there's this obligation or duty of American Family to cover these kinds of claims.
Correct.
So you're not focused on is Lenox liable or not?
No, sir.
Okay.
No, sir. This is simply whether the plaintiffs have the ability, standing to bring or assert this declaratory judgment action directly against American Family Insurance. I will point out that in the plaintiff's complaint, paragraph 82 says that they state their declaratory judgment claim is only to determine the generalized interests of how they litigate their underlying lawsuit against Lenox Green. So I put that out there just because of the substantive issue of what they're looking for in this declaratory judgment action. First, getting toward standing in this, the only named insured under this policy is Lenox Green. Okay. There are two additional insureds under the policy. That's Community Management Associates and Access Management Group. And Your Honor, those are just, not just, but those are these companies that come in and manage the HOAs and collect dues and whatnot. The policy does not define the plaintiffs or give any sort of indication that they would be insured under the policy, either under the policy's definition of the insured, it is the employees of Lenox Green, because it's a corporation, be directors, it would be employees, volunteers, people of that nature. And the statute that requires Lenox Green to obtain some sort of insurance here, so I can give you the site to that.
This is, I think I've got it. It's the 243107.
Correct. Yes,
okay.
sir. It does not provide, from what my reading of it, any right for a third party to assert any sort of action directly against the insurance carrier. So there's no dispute here, as far as I'm aware. I haven't seen anything that, one, the plaintiffs are insureds, they're additional insureds, that they are identified under the policy, that they're not third party beneficiaries because they are not identified under the policy, and they don't meet the grounds for that. For standing here, the plaintiffs have to show, in order to assert this third-party claim against the defendant's insurance carrier, the plaintiffs have to show that either they have an unsatisfied judgment, that the contract, i.e. the policy, gives them permission or a right to assert a direct claim against the insurance carrier, or there's a statute that allows them to assert that claim. None of those are present here. None of those are present. With regard to the plaintiff's claim that they are third-party beneficiaries, there's Georgia law that states the mere fact that a third party would benefit incidentally from the performance of a contract is not alone sufficient to give such person standing to sue under the contract. And the site for that is Page versus City of Conyers, 231 Georgia App, 264 at page 266. That is a 1998 case. Also, there's a Georgia Supreme Court case, Meyer versus United States. That's 242 Georgia, 126 at page 135, and that's a 1978 case. I'd also cite Southeast Grading versus City of Atlanta. That is 172 Georgia App, 798 at page 800. So as far as the standing goes, John, the plaintiffs just do not have the standing to assert this declaratory judgment claim. And, just by way of adding to it, as far as the bad faith claim that was filed after the summary judgment motion, it's the same issue.
And what is your understanding of what the bad faith allegation is as to American Family?
My understanding is that the plaintiffs submitted a claim to American Family, that American Family denied the claim because they said that the coverage was not triggered under the terms of the policy. That's my understanding of it.
Okay. And that decision was somehow made in bad faith.
That's what they're claiming.
Okay.
Yes, sir. That's my understanding. I don't want to speak for the plaintiffs on that, but
no, they'll have a chance to speak in a minute. But in flagging that and in trying to be efficient, you're saying, look, the same arguments apply. You can't bring a claim of bad faith or failure to cover or any other type of claim, you meaning the plaintiffs, against American Family because we're not their insurer. It's as if I got in a car crash with you and your insurer was Aetna and I bring a claim against USAA. It's like, you know what, we don't, that there's not a connection to, this case is stronger than the scenario I gave because you do have, your client does have a connection to the situation. It's the insurer of the association, but it's not the insurer directly of the individual owners.
Correct. And I think by way of the analogy that you brought up, I think is similar to if someone's in a motor vehicle accident, they present a claim to the alleged at-fault party's insurance carrier and the carrier denies it, saying we don't believe that this is a loss. That party cannot just turn around and sue whoever it may be that's insuring the motor vehicle driver. All right. And then just on the actual substance of the declaratory judgment action, there must be a actual controversy or justiciable controversy for the court to rule on. Otherwise, the court would be simply giving an advisory opinion. The plaintiffs have to show that their rights are in direct issue or jeopardy. And there's a case here that states that declaratory judgment will not be rendered based upon possible or probable future contingency because such a ruling would be an erroneous advisory opinion. And the citation for that is Board of Natural Resources of Georgia versus Monroe County, And that's at 252 Georgia App 555 at page 557. That's a 2001 case. And here specifically what the plaintiffs are requesting in their declaratory judgment action is that they want the court to determine their generalized interests on how they litigate their underlying lawsuit against Lenox Green. It's just a contingency claim that they may have that, one, they will obtain a judgment against Lenox Green, and then can they recover that from this insurance policy? At this point, they have no judgment that's unsatisfied. They have no judgment whatsoever, yet they're not directly adverse to American Family. They have, there's no privity of contract with them. So, Your Honor, I would state that, that here, one, they don't have standing, but two, there is no controversy fit for a declaratory judgment right now.
Okay. If we fast forward and there's a trial or a settlement or who knows what, and there's some formal legal finding that Lenox Green is liable to the plaintiffs, then we've moved from that conditional, if Lenox is liable, to Lenox is liable. And then I think this is your point. Then there might be standing to say, well, American Family, you need to step in. You're declining to cover this, and they're liable to us. And why aren't you insuring them in this instance? Because they're saying we don't have that kind of money. But that's not where we are yet.
That's correct. That's correct, Your Honor. Yeah, if that actually happens and they get to that point, and then there's another issue that's not what we're here to discuss today, whether there or not there is coverage for this claim and for whatever damages plaintiffs may be awarded.
Okay, got it. Thank you.
Thank you, Your Honor.
Mr. Kaufman, the motion for summary judgment as to the deck action and informally the bad faith. I know that's not officially before us, but we might not need to drag everyone back in here if people agree that the reasoning, whichever way I go, would apply to both counts.
I think I can make it a lot easier for you, Your Honor.
Excellent.
Their own deck page lists the additional insureds as the manager or lessors of the premises and lists each one of the units by specific number. It's their own exhibit to their own deck page. Their own pages list each and every one of the specific units.
So show me where I find that.
I
think it's the only exhibit to their FSJ.
Yeah, it's the only exhibit in there. I can approach.
No, I can look it up. Let me just.
Well, as you know how easy these are to read, but you could read. They do it by the premium for each one. So
all right, hold on. Give me 1 second.
Section 2 liability and medical expenses is a good place to start.
Now you said it's an exhibit. It's attached to their motion.
Correct, Your Honor.
Okay. All right, I've got their motion. And it's a long policy. Okay. And you're saying it's where?
If you go into Section 2 liability and medical expenses.
I want anyone to number the policy consecutively.
Yeah, it's like page 13 of 14 in this attached. I would have gone digital, but last time you yelled when I broke your Zoom, I believe.
I'm sure you didn't break the Zoom. Section 2 liability and medical expenses. Looking at it.
Perfect place to start.
Okay.
You can see right there, it says the following is changed to additional insured manager or lessors of premises, designation of premises, part to you, and then you start reading units number 194 to 207,
sure,
208 to 221, continues throughout. If you keep going into the next section.
So these condominiums are
so their unit numbers.
Are they owned or leased?
Well, they're owned by the individuals. Some people are leasing them out.
Okay, but let's just take Mr. Clayton then. What unit was he?
215.
Yes.
Okay, so he in theory is part of, on that same page, page 13 of 14, it's got units 208 to 221.
Correct.
But the additional insured is the manager or lessor of unit 215. He's the owner, not the lessor. And he's not the, I don't know what manager means. I would take it to mean like the property manager. So that's who's insured. How do you read this to mean that the owner is insured?
Well, because if we continue into the next section, if you go 3 pages more, the statement of values, blanket coverages.
Yep.
Here, they do it by each particular unit and their individual valuations. And it continues literally by each building and then specific units. So I think that gives one argument that they are specifically written into the agreement. But there's 2 other reasons why that matters, which I think I can help with the court. One,
tell me what your clients pay for this coverage.
well, it all gets assessed to them, which is the other part.
Is it detailed that way? That the assessment is here's for common elements, here's for security, here's for insurance.
That I can't speak to, but I do know that it gets passed directly to them.
I didn't think the association paid for it out of their own pocket.
That's exactly right, but that would be a very generous association. But that's my understanding is they do pay for it. It gets assigned to them pro rata, which also gives you one of the reasons why you would be contemplated. The other is under the enabling legislation code, OCGA 44-3-70, for an association. A condominium association is an artificial entity. They try to say, oh, it's a company. It's like it's not. It's an artificial entity created for the benefit of the unit owners and members. A condominium association's obligations and responsibilities toward the condominium property are dependent upon those allocated to it by this act and those stated in the condominium instruments, i.e. the declaration and bylaws, as decided by a majority of unit owners association members. And that cites the Bradford Square Condominium Association, Inc. versus Miller, found at 258 Georgia App 240 and 244, 2002. The other reason is that is that under section 11 of their own declaration, it reads,
This is the condo.
The condo association, Lenox Greens.
Okay, and where is that in?
It's section 11.
Where do I find the declaration? Part of the complaint?
It's in our amended, it's in the original one?
The original, yes.
Yes, exhibit D. That doesn't come out, something would have been a number.
I think it's just a cap, so I don't think there's.
I see it. I've got it.
Yeah.
All right, so section 11.
Yes, Your Honor. Judge McBurney likes to quiz.
Insurance. Okay.
Okay. And in the pertinent part, it reads, all insurance purchased by the association pursuant to this paragraph shall run to the benefit of the association, continues the unit owners. Further, section 11 states, all insurance coverage for the association shall be written in the name of the association as trustee for itself and each of the owners. That's what it says. So I think we are direct beneficiaries, but even if the court does not define that, even though that's what the code requires, as well as their own deck would require, being a party to a contract, of course, you could be a third-party beneficiary pursuant to OCGA 9-2-20, where the beneficiary of a contract may between other parties for his benefit may maintain the beneficiary of a contract between other parties for his benefit may maintain an action against the promisor of the contract. That's the definition. Well, the purpose of them having this insurance, including specifically water and flood insurance, is for the benefit of these homeowners. That's what they're paying for. So it's the idea that this is just, oh, not our problem. We have a letter that says you can't sue us. That's clearly not the case.
Do your clients have some separate insurance policy for their units? And if so, for what?
They have inside the unit for what they're responsible for.
Meaning like if a pipe burst inside the unit, or if they're cooking and something catches on fire?
That it may depend on who's on fault in that finding, but a better example, theft insurance, or,
You break into my condo, take my stuff, I've got insurance. That's not what American Family is insuring here.
Correct. They're insuring against structural issues. I mean, you've seen it's a very robust policy based and specifically on water. And water is important because if you go back to Georgia Code 44-3-107, I have copies if the court and council wish. And so it's very clear about what kind of insurance an association shall obtain. And it also has the same language that it's going to be such insurance shall cover the following items with respect to each condominium unit, regardless of who is responsible for maintaining them in the condominium association instruments. And it talks about certain issues. However, if you go to section C, it says in the event of a potential, or it also says you can add additional ones as authorized by the board of directors, water as being one of them.
Where are we in section 11, or you?
No, we're talking about Georgia Code 44-3-107.
Oh, okay.
I can provide it.
I've got it. Okay.
Yeah. So one, it talks about what insurance shall be provided. It also says how it should be for each unit owner for their benefit. It lists that out. The court obviously can read under A1. What I wanted to point out is also significant to me under C1 is in the event of a potential or submitted claim related to water damage or water peril on any insurance policy obtained by paragraph 1 is an association, and it says specifically what the association must do when a unit owner makes the request to tender, or if the unit owner makes the claim itself. You have 5 days, and it's very robust, clearly contemplating that specific to water, the Georgia legislature has addressed this very issue specifically. And I'll point out that every single one of American Family's cases is wholly off point. Every single one they cited was either about a car accident and some random person being involved, and it was usually an excess insurer, not the direct insurer, where someone is either a contemplated written-in beneficiary, in my view, or at worst, a clear statutorily contemplated third-party beneficiary, not a utter stranger happens to be on the side of the road. Other cases they cite were someone leaving, at a bar and got in a bar fight. Now, that's a completely unanalogous situation versus someone that is specifically contemplated by their unit to be insured, as well as someone that's actually paying for the insurance. Other cases that they cited about the deck actions were equally just off base. For example, they were involving if a government water authority did certain improvements that they may or may not be affected. That's a hypothetical. Here, there's an actual controversy. There's insurance. We paid for the insurance. We're contemplated under the insurance. It's to our benefit. We made a demand per the statute as required, and they waited way too long to respond. And then they denied coverage, saying, it's not our problem. And so that's why they have two problems. One is I think the deck action will survive in our favor, and the other is that now they have a bad faith claim, and these are relatively large numbers. And so not one case either addresses the idea that there's an actual controversy, and not one of their cases has anything to do with this type of an insurance situation. They've cited this. This Anthony versus Grange mutual casualty case. That case is not analogous. Here, It's about home title insurance being assigned to a second buyer. It's nothing to do with this. You know, it's a home sale that person clearly wasn't in privy of concept. So, I mean, if you go through each and every one of them, which I unfortunately had to read, of course, the same thing, Page versus City of Conyers. This is about the city services and about if someone is what's known as an incidental beneficiary and that person lacks standing. These clearly are, my clients are clearly not incidental beneficiaries. And so that's the standard that American Family is looking at. And it's just not accurate either as a matter of law or fact. So I believe I've addressed their motion. I think it should fail. I'm happy, of course, to always answer your questions, which I know are usually pointed.
So I'm following you as to what I'm going to call ground one from Mr. Wooten, which is no standing. And you've pointed out reasons why there may be fairly sturdy standing. But let's then get to point two, which is, let's say you've got standing. It's still an advisory opinion because there's this contingency that separates where we are now in the litigation and where American Family would come in. Not bad faith, that's not what the deck action is about. But as I understand the deck action, it is, well, there are two pieces. One is, tell us Lenox is liable. And I don't know that, I think that's what the rest of the lawsuit is about. But as I read the other half of the deck action claim, it's, and tell everyone that American Family needs to cover Lenox's liability. And that seems like it's one step down the road. It's an important question. And this is different. This set of facts is different from what I normally see, where before the question of liability has even been approached, the insurer swoops in saying, I want the court to decide in advance, do we need to be in this mix? Because if so, then we're going to spend some money defending the person who is allegedly liable. If we don't think we have to cover it because it was an intentional act or whatever it might be, and that's excluded from our coverage. That's not this case, because we already have, as I understand the record, communication between Lenox and American Family saying, we're not covering whatever happened to these units and the water intrusion, so we're out. And you're saying, no, you need to tell them that they're back in, but they're in if who is liable, and it's Lenox Green would be liable, but that has, I don't know if that's been decided yet.
I think that is maybe a step further than maybe it was meant to be.
Mm-hmm.
Here, it's really the question of, we think we're covered under this policy.
Mm-hmm.
We've made a claim, you've said we're not. And so there's an actual controversy of, are we covered under this policy or not?
So not is Lenox Green covered, but are we, based on this language here, I'm a unit owner, and just reading from the second paragraph of section 11 of the declaration, all insurance purchased by the association pursuant to this paragraph shall run to the benefit of ... the unit owners. So your deck action is, you need to declare that what all this means, and the other things as well, what that means is, in fact, American Family is in the mix. There may be that Lenox Green isn't liable, and then there's nothing to pay out, and we have to go after the builders if that's not time barred. But that's sort of the other part of the litigation.
Fact questions. I mean, our view is, we made a claim and you denied it. Our understanding is Lenox also made a claim and they denied it. And so we need to know, are they in the mix or not? Because, if not, we may have other remedies. They may be insurance commission remedies. There may be other, types of claims. There may be appeals. But we need to know that answer now, if they're in or out. Whether it's, and why they're in or out doesn't really matter, if it's because Lenox brought them in and they should be, or if we brought them in and they should be. Obviously, it'd be easier if, maybe they're in on both reasons, for later down the road. But those are all factual issues to be determined after we know who the parties are. And that's maybe slightly more detailed than it was pled, I guess.
But why is it not a response to the DEC action to say, as to American Family, is too soon? We need to sort out whether Lenox Green is liable or not, because if they're not, then what does American Family have to do with this?
Well, the answer to that is, hey, we're also a beneficiary. So
Okay.
just because you have that feeling about Lenox, that's nice, but we have equal standing.
And it's an allegation in your complaint, and I know we're early on in here. It's an allegation in your complaint that your clients went to American Family saying, cover this, and American Family either said, you aren't a policyholder, or we won't cover it, or whatever. The answer wasn't yes.
In fact, it wasn't even we'll take it under reservation, which is what, given your example of a fact pattern, is what most insurance companies will do if they don't know the answer right away. If they go, look, we don't know, we're going to take it under reservation, we have a duty to defend, we'll look into it, and then we'll at some point either pay out, realize our policy requires us to do so, or go, hey, that's not our problem. Here, they just rejected it and said no.
Okay.
And that's the problem, and that's why.
But that request came from your clients.
I believe it came from both. I believe Lenox Green's prior counsel also made the request, is my understanding.
I understand that part. I just wasn't remembering.
We made their demand pursuant, and that's exactly also what I was pointing out under the 44-3-107C, is that specific for water damage, water peril on any insurance policy, it's contemplated that the tenant or the unit owner, the beneficiary, can is obligated to receive from the association, if they have it, any potentially applicable insurance policies for the sole purposes of them making that demand.
And what is your understanding of what American Family said in response to your client's demand?
I would have to look, because we made the demand and it took so long to get anything back, and then it was like, it's just rejected. We're not.
Okay, but when you say reject, I'm just curious if it was a lot, you don't need to quote it verbatim, but if it was, you're not covered, or we don't cover water damage, or it was a construction defect. I mean, those all could be connected to the answer.
It could be, but I believe it was, I'm trying to find this. It was just, you're not the insured, was my understanding, but I can that's what it said.
Yeah, that's what it said.
Yeah.
Okay.
Yeah, and it was like, okay, now what? Because
Right.
frankly, part of the conversation when we had that precondition meeting with the board was they wanted to hopefully get insurance that was applicable. You know, that was one of the reasons that we had that discussion.
I appreciate what the declaration says. What if the policy is properly, the policy that was actually obtained is properly, as it's written, construed to provide coverage only to the association?
Well, I think
I know you're arguing it doesn't. You pointed, hey, look, each unit is in there, et cetera. But I'm just wondering if we have a set of facts where the association should have obtained a policy that explicitly is for the benefit of the owners, but for whatever reason they didn't. And so the policy, as read by a layperson, looks like, you know what, this just covers the association. It doesn't cover the owners. It should have. It's a violation of paragraph 11. But then American Family is saying, well, you know what, that's not the policy they got. Maybe they should have gotten a different policy, but the one they obtained and that your clients have been paying for through assessments simply doesn't cover the owners. And so it was a contractually correct answer to say to your clients, you're not covered.
well, then at least part of the policy under the Georgia Code would have still required it to apply to the condo owners as well. I mean, that's what CGA 44-3107A says for those mandatory requirements. It says the association shall obtain it. And it says that, you know, obviously if they're offering a policy in Georgia for this specific purpose, it needs to comply. So at a minimum, these minimum standards under section A1 would include the beneficiaries. And so that's the problem. If they said, hey, absolutely, you're not even in here, you're not contemplated, you're a nobody, you're no different than the guy walking in off, getting in a fight at a bar, then frankly, I imagine Commissioner King would take great issue with American Family. So, I think that's the problem they have. The idea that you're just a total stranger is impossible, because there's no way they could write a policy for an association in Georgia with condos without contemplating the owners.
And last thing, and this I think gets more to what we'll be hearing about when I hear from Mr. Stacy, but if the position is, maybe you've got coverage through both the policy and the requirements of the declaration, but this is a construction defect and that's not covered by the policy. Yes, it rains, and yes, the rain comes off the roof, but the builder built patios and balconies that have the reverse slope. And that's tragic, but that's not something that the association would ever be liable for.
I have two answers for that. One is I've known Mike Stacy since law school, and he introduced me to my ex-wife. So if he says something, just grain of salt. No, just kidding. In all seriousness, it's too soon. It's too early. Those are all fact questions down the road. This is for a motion to dismiss judgment on the pleading stage. That's completely.
So I'm not asking about it from Lenox Green's perspective. It's on this motion for summary judgment, American Family. He said, look, we've looked at this and there is water damage, and it's not a pretty sight, but it is the product of a construction defect and we don't cover that. Well, and that's why we're rejecting your claim. Well, and they may have said both. We're rejecting it because we're rejecting the claim filed by the owners because you're not covered. We're declining to cover what Lenox Green, because it sounds like Lenox Green also said, hey, will you help with this? And American Family said no. If their answer was it's a construction defect, that's not in any policy, it's not in 107, why aren't we at a close there?
Well, I think for a couple of reasons. One is, one of the claims is about delay and failure to maintain. So just because if there's a construction defect doesn't mean you can't maintain it. It doesn't mean that's the sole cause. It also doesn't mean the fact that they waited 7 months to do anything about it, which obviously is this continuing issue. And so that kind of changes the actual situation from what I believe is your quasi hypothetical, because the other thing is that position is not the position they've taken. Their motion before he doesn't say, here's the policy. We don't think they were beneficiaries, but even if they were, it would have been excluded for this reason. That's not the motion before the court. And so, an interesting mental exercise, maybe it'll bring us back, but that's not the issue. The issue is, as they play it, is, hey, tough, you're not a beneficiary, and we rejected it.
Okay. Got it. Thank you.
Thank you, Your Honor.
So, Mr. Wooten.
Yes, sir.
Mr. Kaufman has tied us, connected us to some documents that seem to say that the condominium owners are beneficiaries of the policy. How do you disentangle your client from that kind of language?
What I believe what he's referring to is on the declarations page, where it lists all the different properties that are there.
So two things I want us to talk about. One is language in the policy, no question about that. And that's to me the more opaque language because of how declarations are done, policy declarations. But also, I know this isn't your client's language, but the condo declaration that we were looking at, that section 11, and I can put it up on the screen if you don't have those documents. But let's start where you started, which is the policy, the endorsement and the declaration that appears to say that what's insured are all these units.
Okay. And that is merely there to specify or show, like, hey, we have Lenox Green Condominium Association. They're wanting insurance for properties that are here. And the coverage is, what we're dealing with here are common areas. And, there's common areas such as, I don't know if there's a playground there or not, but a swimming pool, fitness center, those sort of things that you have. Mm-hmm. But also, with my understanding of this is that includes the exterior of the units. like we're talking about the balconies, the patios and things such as that. But again, the insurance that they purchased for that, and you have to identify that somewhere in the policy that, oh, we have X number of buildings with Y number of units inside those buildings. But again, the policy, when you come down to it, as far as who the named insured is on there, and that's the contract here that we're talking about, and whether the plaintiffs have a right to a certain thing under that contract. The plaintiffs are not named insureds. They're not identified as an insured under the policy. They are not additional insureds. And there's nothing in the policy, the contract that they brought the deck action about. There's nothing that gives them the right to assert that action or a direct action against the carrier in this. And I think similarly to what you asked about and I don't have it in front of me, but the declarations for the HOA, that's a separate document. Okay, that's between plaintiffs and Lenox Green. And whether there's a breach there or not, my client's not involved in that. They're just sort of I don't know if collateral of that, but they're sort of over here, and they had really nothing to do with that. And they can't be liable under that document. They're not a party to it, and it's not applicable to them.
So it could be that the association was supposed to get a certain type and scope of coverage pursuant to the COA declaration, but what they ultimately purchased through American Family doesn't actually match up. And to your point, that may be an issue for the association, but American Family said, what is it you want? You want X, Y, and Z? Great, that'll cost you $100,000. Here's X, Y, and Z. And if that didn't include A, B, and C, but you were never asked to provide that, how possibly is American Family liable for that?
Correct.
Can you walk me through, and if you want me to put it up on the screen, I will, the policy. I appreciate your distinction about the COA declaration. And the language there to me is pretty clear. It's not binding on whatever insurer it might be. It's an obligation of the association and its members. But the insurance policy, I want to see.
And if you have the actual page number I don't know if you have the PDF page number. I have the policy pulled up, but.
Okay, so what I have as the attachment to the complaint, page 13 of the PDF is what looks like the first page of the policy that was attached.
Okay,
I don't know if that helps you.
To the plaintiff's complaint?
Yes.
Okay.
And I'm happy to put it on the screen if that helps.
Let me see. That would help me, Your Honor.
Okay, let me do that. All right, do you see on the screen now? Let me get that out of the way and that out of the way. So this is the first page of what was attached.
Okay, because it's everyone was saying it's a pretty hefty policy here. It's 125 pages. So I'm just trying to see what the context of this is here. Again, Your Honor, this is, I believe just going by what we're seeing here, that this is just stating these are the actual properties that are on site that coverage could apply for should any of these people identify as an insured under the policy.
Okay,
so against them related to those. Got it.
And one of the things Mr. Kaufman was pointing to, if we go down it's listing all the units. You can see on page 9 here, it's units 127 to 140, but you're saying this is just a more specific or particular description of the premises that are covered.
Correct.
So where do I find who the insured is?
The insured, I'm looking at my policy, the copy of it, the hefty one here. This was exhibit 1, I believe the only exhibit to American Family's motion for summary judgment.
Okay, well, let's use your page numbers. I can do that. All right, so what page should I go to in yours?
Let me find the citation to it here. It's going to be on PDF, should be on, let me double check and confirm that it's actually there. Yeah, PDF page 8. This is of the, if that helps you at all. It's under the American Family Policy. This is going to be, where that was. I believe it was up above that, Your Honor.
Well, so
See, I can tell you what it says though.
I'd like to read it, but it's one of these classic insurance things because it, like the riders and the amendments are, so here's the business owner policy.
Yes, sir.
All right, so keep going.
All right, keep going.
So section 1 is property.
A little bit further.
Liability. Keep going.
Let me see 1 second here. It's going to go under, keep going, I believe, keep going. I believe it is after that.
Coverage form.
We've gone too far. I'm sorry, Your Honor. I know that it's 8 pages into the actual policy.
Okay.
I'm sorry, into the PDF. I apologize, Your Honor. It's 8 pages into the attachment. So it would be further up.
Well, eight pages into the attachment is the attachment starts
Okay,
with
that's not it. Yeah.
that. And so if I go 8 pages in, that would get us to page 19, which is still policy changes.
That is, you can see it there. Let me see if that's the same page that I'm on. 1 page up above that, I believe. Okay, and if you see there, it has, let me see here. At the top, issued under policy number, it should say issue to Lenox Green Condominium Association.
Okay.
Then below that, where there's the boxes and such, it has below there name of person or organization, or that's the additional insured. That's where it lists Community Management Associates and Access Management Group.
Okay, here.
Yes, sir.
All right. So a literal read of this would be that the 3 entities covered to whom the insurance was issued is the condominium association and then these 2 groups that help manage the property.
Yes.
Okay, so it's not literally that the owners are on here, but if there is a compelling argument that the owners are the natural beneficiaries of any coverage issued to the association, that's what I need to work through. That is a beneficiary argument that would empower an owner of a unit to say, well, actually, this policy covers. I can bring a claim as well, not for someone stole something from my unit, but there's this water damage to my sliding door. It won't open or close anymore because of water coming from the outside. And if this policy covered water damage, that would be how I would articulate it, that I'm not the association, but the association is me and you and all these other people. And so I'm able to bring a claim under this policy. I'm not asking you to agree with that, but I think that's what I'm hearing Mr. Kaufman say.
I believe that is what he's saying. However, I would then go to the definition under the policy of an insured.
Mm-hmm.
Okay, and that's way inside there. I think it's page 73 of the policy itself. And it's a very lengthy description of who is actually the insured under the policy.
Mm-hmm.
And the owners are not insureds under the policy. Like stated before, it's the members or the executives with the corporation, employees, volunteers. People such as that. So they're not listed as insureds who would have the right to bring the claim directly against American Family Insurance.
Okay. Got it. Anything else you want to say in response?
I believe that's it, Your Honor. And I would just add here too, Your Honor, went towards it that it's not ripe yet for a decision. It's just an advisory opinion. Well, if we were to get in a judgment, we being the plaintiffs, against Lenox Green, then we want to make sure there's some money there for us. Okay, but they are not there yet with it. And we don't want to get into the details of the reason for the denial coverage. It was a 6-page denial letter that set out here's the policy and why it's not being covered right now.
Do you know if that's in the record, or you
Not in
just
the record.
happen to know it's a 6?
I just happen to know that.
Okay.
That's
Got
not
it.
in the record.
Okay. Thank you.
Thank you, Your Honor.
All right. Let's hear from Mr. Stacy and his motion.
Your Honor, before you begin, can I just point the court to OCGA 44-3107 A2, which is the requirements of what a insurance policy must include for an association. And I'll note in it, it says the policy or policies, and this is about 2 reads, a commercial general liability insurance policy or policies affording coverage for bodily injury and property damage in an amount not less than $1 million for a single occurrence and $2 million aggregate. The policy or policies shall cover the association, the board of directors, and the officers of the association, all agents and employees of the association, and all unit owners and other persons entitled to occupy any unit or other portion of the condominium for occurrences for occurrences commonly insured against arising out of or in connection with the use, ownership.
I can see it, and I just underlined all unit owners, but
Then it's not about a policy.
okay, but why is that American Family's problem?
Well, because they sold insurance that to specific use for a community association that violates Georgia law, and so they're going to do that at their peril. I mean,
Okay, but that's not, I mean, you don't have a claim in this lawsuit that it was a bad policy or an inconsistent policy. Your claim is either we're covered by it, and you did a bad denial. But if the policy as written, in fact, doesn't include your clients as an insured, there may be legal ramifications for that. I don't know that they're before me at this time. Do you agree with that?
I think either we are directly or a third-party beneficiary, which is also specifically contemplated
Okay.
by the code.
Okay, and if you're not directly, there could be a problem with the policy, but if you're a third-party beneficiary, we can skip that crisis. About, gosh, based on 107, really the insured ought to say, and all unit owners.
Well, it gets to the idea that, well, you're not just a beneficiary, you were actually a bona fide purchaser for value, we were paying it. So the question of then, maybe between American Family and Lenox pointing fingers, but I still don't think that puts us as their case is put it, if you're incidental, not less than a third party beneficiary. Here, the code specifically gives the right to make you a party to an action if you're a third party beneficiary with a specific purpose.
Well, I cut you off too soon when you were reading that 107, it's unit owners for occurrences commonly insured against arising out of the use of common elements. And that gets you to your roof. That doesn't get you to your porches and patios and balconies, because that's I think everyone agreed, a limited use or limited common element. And that's not what A2 is about.
Well, it continues, of course, after common elements or other portion of the condominium which the association has a responsibility to maintain. And that's one of our claims against Lenox, is that they were supposed to maintain both the roof as well as these all exterior portions, including those patios.
Okay, is there something in either the declaration or some code provision that says that Lenox had the responsibility to maintain the patios and balconies?
Yeah, it's in the deck, it's in the decks.
Is that the 17B?
17B.
Okay, well, we'll get to that. I think that's going to be for Mr. Stacy to discuss. All right, Mr. Stacy, I know you were starting to get up, but your turn.
That's all right.
It's all right.
Thank you, Your Honor. Again, my name is Mike Stacy. I represent Lenox Green Condominium Association. The court at the outset of this hearing addressed some of the housekeeping matters about what's in and what's out. And I think that that's helpful. I think at this point in time, what's left would be something that I would sort of say is the meat of the case, and then a couple of ancillary issues. The ancillary issues being the punitive damages claim and the breach of contract relating to the insurance coverage matter, at least as to Lenox Green. But the meat of the case is as to really two issues. What was Lenox Green's responsibility vis-a-vis these units, whether it's the patios or the roof? And what is plaintiff actually alleging now in the first amended complaint? And I'll take those in order unless the court wants to hear them out of order. As far as what is the Lenox Green's responsibility, the declaration is clear that the obligation is to keep and maintain in good repair the limited common elements. And as argued in the motion, those words, which are required to bear their ordinary and customary meaning per Georgia law, do not require that the association step in and improve them to a condition better than what they were constructed in. I don't know if, and I'm not sure that anybody knows right now, exactly what condition they were constructed in 1990 and whether it was up to code or whether it slopes back or whatever it may be. If it does slope back, if it's not up to current code, that's unfortunate. That is not the obligation financially of Lenox Green to repair. So the argument was made in the motion.
If it's not Lenox Green, assume for a moment that the balconies and patios are not up to code. They slope in the wrong direction. They're limited common elements. Lenox Green's obligation is to maintain them, but that doesn't mean bend them the other way. So, hey, they slope this way. There's a crack. We'll fix the crack. But we, Lenox Green, are not obligated to change the grade, if you will, of them. Whose obligation is that?
That would rest with the homeowner, the property owners.
Okay.
I believe the default is that the property owners essentially have the responsibility, the association does not. And the association is given specific responsibility, which is to keep and maintain.
When I buy a condominium, do I get it inspected like I get a house inspected?
Absolutely.
And so an inspector should have told each of these plaintiffs, this is a beautiful place. However, your balconies and your porches, they slope inward. That's not going to go so well if it rains. And then the prospective buyer could say to the would-be seller, I'll buy this, but you need to take 10 grand off the price because I'm gonna have to spend some money on fixing this balcony. It slopes the wrong way.
Correct. And apparently there was also a lack of adequate flashing on the exterior part of the unit. So when that water was allegedly coming into the unit and hitting that exterior wall, there wasn't anything to create a nice watertight barrier. So the problem was exacerbated. I can't speak to what an inspector may or may not have known at the time, and at this point in time, at this stage of the case, that would be a factual issue that we don't need to address. The broader point is that when the plaintiff amended the complaint, the theory of the case changed mostly 180 degrees. And suddenly now the theory of the case is actually the water wasn't coming from the porches or wasn't only coming from the porches, it was also coming from the roof. Obviously, the Lenox Green very much disagrees that it has any liability here, but if there was water coming from the roof, which is a common element, there would certainly be an argument that Lenox Green had responsibility. And we're not saying at this point in time that that claim is subject to dismissal. The concern is what was left in the amended complaint, and it's not very consistent, appears to be both that the water intrusion was caused by the roof and it was caused by the patios, which may have been improperly sloped, which again, we're only responsible, if anything, for, I guess, half of that. And so
there needs to be some clarity here that the obligation of the Lenox screen does not extend to any damages, which is the plaintiff's responsibility to demarcate in terms of dollars, that were caused by this allegedly improperly sloped patio. And having said that, obviously if water came down on the patio and let's say a joist rotted, that would be on the association, because that's to keep and maintain and bring it back up to the repair condition that it was in. But if water is coming off of the roof, it's hitting that patio, or coming from the sky and hitting that patio, and because of the improper sloping is entering the property, that's not Lenox Screen's issue to solve. And so the purpose of the maintaining of the motion to dismiss post-amended complaint was to make sure it is clear to the court, and hopefully the court agrees, that the responsibility of Lenox Screen does not extend to that, and to the extent that the claim is still based upon that, it needs to be dismissed. And I'll point out to the court, the damages that are being alleged in the amended complaint are to the dollar, I believe, the same as what was alleged in the complaint. The complaint was based off of the engineering report, which was basically completely devoted to the issue of the improper sloping of the patio. So there's a disconnect here as far as what the plaintiff's allegation is, or the claim is, and obviously some aspect of the claim is based upon the improper sloping. It should be dismissed. The other two issues, Your Honor, and again, I'm happy to address any of that in more detail. The other two issues would be, one, the punitive damages claim. The initial allegation was simply a stock phrase of whatever the elements are in terms of, it was willful and wanton and malicious. I'm not sure in a breach of contract and negligence case how we get there. I think at most, and again, denying all liability, we're talking about a 13-611 issue, not a punitive damages issue, but it was a stock phrase. When the motion to dismiss raised this issue, there is now an allegation in there that because this engineering report was not provided to the homeowners in supposedly a timely fashion, that establishes the willfulness and wantonness of sufficient to maintain punitive damages. The engineering report that supposedly undergirds the punitive damages claim is entirely based on the improper sloping, which appears to be not the primary theory of the case anymore. So I'm unclear as to how the failure to provide a report that doesn't address the thing that plaintiffs now claim is the issue could support willful and wantonness. And I believe, and Lenox Screen believes, that as a matter of law, that has not been sufficiently alleged. Certainly, if it were to be dismissed and later evidence were to come out, it would be something that the plaintiffs could replead. But at this point in time, punitive damages don't lie. The last piece is there's a aspect of the breach of contract, which is a breach of the declaration claim regarding the insurance coverage. And it is not what the court was alluding to in the prior argument, which was whether the homeowners association procured the correct coverage. Rather, it is some allegation that we didn't pursue it or recover it before going after the homeowners on a special assessment for these repairs. There's nothing in the policy, there's nothing in the law that requires that be the primary source of recovery, or the first source of recovery, or the only source of recovery. And this notion that somehow it's a breach of good faith and fair dealing not to have pursued that, it simply doesn't make sense. Where does that stop? Do you have to send a letter? Do you have to send 10? Do you have to file a lawsuit? The reality is the plain language of the declaration and the plain language of the law says we have an obligation to secure this coverage. Lenox Screen did. As Mr. Kaufman mentioned twice, Lenox Screen had apparently had made claim as well, and were told it's not covered for the same reasons that are being argued here today on this motion. And that's a separate issue that will have to be addressed with the insurance company at some point or another. But the fact is, having not received that insurance proceed, that doesn't mean that Lenox Screen can't proceed against the homeowners in a special assessment, particularly where, in theory, they could be timed out after a period of time by the statute of limitations. So it simply doesn't make sense that would be the argument.
Let me see if I have questions. How would you envision something being worded if there was going to be something to this effect, saying, hey, this case is still going forward. Not everything is being dismissed at this early phase, but this is about the roof and not the balcony, because the balcony or patio, because that that limited common element isn't something that Lenox Green is liable to replace or repair. It's keep and maintain, and anything beyond that is the responsibility of the unit owner. This is something you alluded to earlier, that we now have this sort of mixed claim of water from the roof. That's a common element that is squarely in Lenox Green's lap, versus water from the patio. They're clearly connected, because if water from the roof goes onto the patio, then there's water from the roof on the patio, and it's not going into the unit from the roof. It's going into the unit, roof, patio, into unit. So they're linked. And I struggled a bit as I was thinking through your argument this weekend, and as you articulated it. Is that something that is a ruling in advance, or it's more of a jury instruction / on the verdict form, which is allocate, it wouldn't be worded quite like this, fault to roof versus fault to patio. And if the fault to patio is greater than 50%, then maybe there's no recovery, or it's still a recovery for the plaintiffs, but it's reduced by the percentage that is the fault of the patio, if you will.
Sure. I think it could be done in one of two ways. And I understand your point, and I've wrestled with the same issue because it's pleaded as one count. And so it's difficult to say, well, you can't grant the motion in full as to the full count, and we've conceded that point. I think it can be granted to the extent that the breach of contract claim is attempting to state a claim based upon the patio involvement. Alternatively, and I think that Lenox Green would be okay with this, it would be something more in the notion of a motion in limine or a jury instruction that basically prevented this from getting in front of the jury in such a way that now the patio issue is infecting the ultimate issue. And I do think that
I just think that's going to be complicated, because if I'm defending Lenox Green, I'm saying, sure, there's water coursing off the roof onto the patio. That happens everywhere. Look at these 20 units. It goes from the patio out to the drainage ditch. But these 20 units, or these 4 units, it's going into the unit. But that's because the patio's messed up. And so the patio would be woven in either from the plaintiff saying, look, it's a faulty patio, and there was this obligation that you'll push back against of the association to do something about the patio or the balcony. But that same factor would be what you'd be pointing to on behalf of Lenox Green, saying, yeah, water comes off roofs. That happens everywhere. But for the faulty patio, not our responsibility, there wouldn't have been water damage and water intrusion.
Right. And again, I think it's a difficult issue is from a procedural perspective. I think to the extent that the court rules that to the extent it's stating a claim based on, or attempting to state a claim based upon the patio involvement, it's dismissed. That would make some sense. Again, as far as it doesn't dismiss an entire count, it makes it problematic. I don't think that Lenox Green should have to go through a bunch of discovery about an issue that shouldn't be in front of the jury to begin with. So I think it could be handled that way. It could be handled with a jury instruction or with a motion in limine, but I don't think the jury should be in a position to even contemplate that. One other thing, Your Honor, I omitted it. There has been some suggestion that this second sentence in 17, I believe it's 17A, or not second sentence, excuse me, the paragraph in 17B beginning, the association shall not be liable for injury or damage to person or property. It's the bottom of page 30.
Yeah, let me get there. All right, 17 is maintenance responsibility. A is by the owners. B is by the association. Okay,
correct. There's been some suggestion in the briefs that by the plaintiffs that this paragraph is somehow expanding the association's liability, that by saying the association is not liable for damage by water unless they're put on notice, that means if they're put on notice, they're liable. Number one, I'll point out to the court that it's qualified by for which the association is responsible to maintain here under. So if we're not responsible to maintain it, I'm not sure how that would flow just from a pure grammatical perspective.
So it's really saying first of all, we are responsible for certain things. If you don't tell us about it, we're not responsible at all. You got to give us notice. Once you do, then it needs to be something for which we are elsewhere in the declaration responsible, and then certain provisions may kick in. But if you don't tell us about it, then even though we might otherwise have been responsible for it, we're off the hook.
Right. And look, I didn't write this, this declaration, but as somebody who does do a fair amount of transactional work, I wouldn't say it's particularly clearly written, but I think what this paragraph is actually referencing is premises liability issues in terms of maybe somebody coming and slipping and falling or on something. But I think the point is undergirded by the fact that at the outset of B, it doesn't say except as otherwise provided here, which would qualify the obligation to say that there may be a point in time where the obligation is modified. So just from a pure textual perspective and contract construction perspective, I don't think that argument has any merit.
Okay.
Thank you.
Got it. Mr. Kaufman.
Let Mr. Zim have.
Mr. Zim. All right, let's do it. It sounds like, Mr. Zim, so you don't need to spend a lot of time on this part. The association is conceding that any liability claims that you would be advancing that are connected with the roof aren't appropriately dismissible at this time. So you don't need to spend time defending those. It would be other things.
Okay, yeah, that's fine. It ties in, however, to our claims, because I want to go and begin on section 17B, which Mr. Stacy just mentioned, that this section here does not have anything to do with premises liability. It is directly on point that, and I don't think I need to read the entire section here, but it's clear that—
Well, I'll note in conjunction with what you're saying, the section 17 is maintenance responsibility, not I got hit on the head by an intruder or I slipped and fell. It's maintenance responsibility.
Right. Okay. Right. And it's clear here that the association shall not be liable on the first clause, and it moves to resulting from any utility, rain, snow, or ice, which may leak or flow from any portion of the common elements. And what is applicable here is obviously the roof. The roof is a common element that is overflowing onto the balconies / patios of each of the plaintiff's units, and which is the substance of the plaintiff's breach of contract and negligence claims. And the exception here clearly applies. The homeowners put the association on notice as soon as May of 2020. We are in January of 2025. It's almost been 5 years and nothing's been done to these units, which goes to the punitive damages argument that I will get to in a moment. But clearly the exception applies here. Whenever it rains, and it rains even this morning, this is a continuing damage of the roof overflowing. It's not properly constructed. The rain is going onto the patios and the balconies, and it's overflowing into the plaintiff's units. So clearly they could be liable under section 17B for being put on notice for almost 5 years and not going ahead and fixing this issue. And it seems as though, although I don't want to put words into anybody's mouth, but it sounds as though that Mr. Stacy and us agree that the association does have an obligation and a duty by the clear language of the declaration to keep in good repair and maintain all the limited common elements in the association. And as the court mentioned earlier, is that, well, if the association is not taking responsibility for the limited common elements, such as the patios and balconies, then who is? And clearly under these, the declaration, the association is responsible for it.
So I don't know, there's a disagreement there. I thought the declaration, I'm sure you know where it says it in there, that Lenox Green is responsible for maintaining the limited common elements. So isn't our debate, well, what does maintain mean? And if, to me, maintain would mean keep it as it is. And if it is at an improper grade, it's not the association's obligation to regrade it.
And I would agree. And that's actually what the association mentions in this motion to dismiss, is that it's in this as-is condition, but that does not absolve or excuse Lenox Green's responsibility to maintain and keep it in good repair. If it is defectively constructed, they still have to maintain and keep in good repair. I don't care if they have to get a squeegee out every week, every time it rains, they have to maintain and keep in good repair those patios and the balconies as they are obligated to do under Section 17B.
Talk to me a little bit about that, because it sounds like one of the things your clients allege is there has been damage to the patio or the balcony, or maybe wood around windows, or if there's a sliding glass door, as a result of the pooling of the water. So maybe the balcony is defective, but this duty to maintain would be, originally the wood wasn't warped or rotted. It has become so. May not be Lenox Green's fault that it became so, but it is nonetheless in need of repair, and it hasn't been repaired. True statement?
Correct. Yeah.
Okay.
Right. But that also gets into the negligence claim, which is that their neglect to maintain and keep in good repair the alleged defectively constructed patios and balconies, that has resulted in further damage inside the unit and the framing. And this has been known almost 5 years since this has been going on. So there's clearly a duty between you moving on to the negligence claim. There's clearly a duty for them to maintain and keep in good repair the limited common elements. And so it naturally flows that if they are not maintaining and keeping in good repair the limited common elements, then they can also be not liable for negligence, which has been happening. And there's mold. The framing, which is wooden, is coming off the sliding glass doors. All sorts of issues, as you can imagine. Having moisture in your unit. These people have been living in these conditions for the last 5 years. It's getting pretty rough. Every time it rains, there's an issue. So the breach of contract claim is a valid claim under Georgia law for breach of Section 17B. They have not maintained and kept in good repair the balconies and patios. And so
what was it that your clients, and maybe it hasn't happened yet, I know part of the dispute here has been determination that work to the tune of, I'm going to get the numbers wrong, $250,000 has to happen for all the units combined or each one individually. P.S. We're issuing a special assessment, unit owners, for you, because it's your unit. It's not the guys across the courtyard. It's your units, and so they shouldn't have to have some pro rata share of that. And so we will maintain it, as in go in and get a contractor to fix it, but it will be specially assessed to you to fix, to pay for. What's the issue with that? If those are the only 4 units that are experiencing this, take away the roof as an issue. It's the balcony or patio that's a construction defect, not Lenox Green's liability or responsibility. But we do come in and we fix these things, but you're going to need to pay for that.
Well, we're not asking for any renovations or necessarily fixing. I think that's a key distinction. Fixing, renovating, that is separate and distinct from repairing and keeping in good and just maintaining. And it's interesting you bring that up, because discovery has been stayed with the motion to dismiss that was filed with the answer. And so there's over 200 units in this apartment complex, and there's other buildings that are having the same exact problem as what these plaintiffs are doing, and what the association has been doing is setting up new awnings to account for the overflow on the roofs that are essentially diverting water away from the patios and the balconies. So this issue doesn't continue for them. So that is another part of this story that is that's important for your to answer your question. But I want to make sure, because the Mr. Stacy and Lenox Green are making that argument, is that we're not asking for renovations or revamping. It's a clear distinction between making good repair and maintaining, as they are obligated to do under the declaration, and renovating, which we are not asking for. So
this special assessment that has created friction, that was to actually renovate. That's not to, I'm going to use the wrong terms, but replace the flashing and put in new molding. So this would be repairing. Well, this would be maintaining. It didn't used to be warped wood. Now it's warped wood because of the water. And so you need to maintain it the way it was. So Lenox Green put new flashing around the 4 units. That's not what the special assessment was. The special assessment was a forecasted price to actually repair the balconies and patios so that they had a reverse grade.
No, it was not about that. The PM&A engineering report that's in the record, that had to do with repairing and essentially remedying the construction defects. So that had nothing to do with repair and maintenance. The two of them are very similar, but that is separate. I mean, and just intuitively, the clients are seeking nearly $250,000 collectively. That's more than maintenance and repair. You're making structural renovations there to address the overflow of the water. So just in of itself, just in the damages that the plaintiffs are seeking, this is which is based off of the report by PM&A Engineering, that has to do with the renovating of the units in the balconies.
And why would Lenox Green be liable for the cost of renovating a balcony?
Well, that is not our claim. Our claim is repair and keeping good maintenance.
Okay.
So that is completely separate.
So the $250,000 includes in it some costs that would actually remediate the problem. It would regrade the balconies. And that's something that you agree would be properly specially assessed to the unit holders?
It could be, yes. I mean,
you're not committing, but if you had a theory that, you know what, Lenox Green's responsible for the cost of regrading the balconies, that would surprise me, because that seems like that is a limited common element, foundational changes to which would be, that's the wrong word too, but changing the grade, that would be an expense that would naturally accrue to the unit owner and not be spread across every unit owner.
Well, it could be. And it's important to note that there's only been one report, one by the association. PM&A Engineering is the only contractor that has looked at this that the association hired. So the plaintiffs are entitled to their own assessment to see, okay, to compare and contrast what is needed.
Okay.
Yeah, it's also not quite as black and white too in that regard, because if they have failed to maintain and repair over the course of 5 years, there could have been additional damage done too as well.
Understood.
So I'd like to get to the punitive damages argument. That it's important to note that, as I mentioned, this was first reported, these issues, to the association in May of 2020. It's almost been 5 years. That in of itself shows that there's been a willful neglect to maintain and repair the patios and balconies. In addition, as we pled in our complaint in paragraph 87, is that defendant Lenox Green has not repaired or maintained even the roof, the common element of the roof, which is, according, as I just mentioned, in other buildings, they are putting awnings and just awnings to divert water off of the balconies and patios, and they're not doing this in plaintiff's building, possibly because of this litigation. But that has not been repaired for the plaintiffs. The excess water from the common element roof onto their patios. And this has been, again, 4 years since this has been going on. And the PM&A engineering report was sent initially to the association on October 27th of 2021. It took the association 7 months to forward that to the plaintiffs. Again, every time it rains, it's been snowing recently, every time it snows, any moisture that's in the air, it's causing issues for the plaintiffs. And I mean, I don't know what excuse they could possibly have. They could easily have forwarded an email or walked over to their units and delivered the PM&A engineering report such that the plaintiffs could either agree or disagree with the report and find their own remedy for the issues that are happening in their units. So clearly, there is sufficient facts for a punitive damages claim that the plaintiffs have pled in this complaint. And I'd like to hear any other questions that the court has, if any.
As I understand the breach of contract claim, it really is, it's got three breaches sort of combined in it. There's an allegation that Lenox Green breached because it's making your clients pay to cover repairs, et cetera, rather than insure. They also breached because they haven't been doing repairs on the balcony or maintaining the balconies. And then the third level is they haven't been maintaining or repairing the roof, because roof and balconies we know are different in that one is a common element and the other is a limited common element. But are all three of those, I mean, they're interconnected, but I think they're separate breaches that you're alleging.
Yes, that's correct, Your Honor.
Okay.
In your honor, part of the deck action issue with the insurance may indicate an additional breach for the failure to have a declaration that had us named as insured, depending on how it worked. Fine. So I mean, you certainly may end up amending the complaint, as of course we can.
Not yet.
Not yet.
Nope, that's it, Mr. Zim. Thank you.
Thank you. Address the court briefly.
Of course.
Thank you, Your Honor.
Sure.
I'll be very brief, Your Honor. As I understand Mr. Zim's argument, and I don't say this to be flippant, but this is an inception level argument here. It's essentially what I understood, and I'm not sure I followed every aspect of it, was that the plaintiffs are arguing not that the association had a duty to remediate or renovate the patios to solve this problem, but every time the problem occurred, to the extent it caused any little bit of damage, now that is on the association, because the association should have done something, presumably renovate the patio to address the issue to prevent that damage from happening again. That functionally, that is a renovation obligation. It becomes a renovation obligation, number one. Number two, they haven't pled a continuing nuisance. I'm not sure, they plead negligence and breach of contract. But, again, I think it ignores that if the obligation to fix the improperly sloped patio does not rest with the association, it rests with the property owner. So this idea that somehow the property owner is not doing what they should do puts an obligation on the association to suddenly come in every single time it rains and do whatever is very nonsensical to me.
But doesn't the addition of the roof as a vector address your concern? I don't disagree with what you said. And if we were traveling under the original complaint where it was, these balconies are sloped the wrong way, and every time it rains, bad things happen. And eventually, and there's, of course, we've got to weave into this. It took a long time to get this engineering report and this and that, but now we're all on notice. It's the balconies are sloped the wrong way. And so precipitation that hits the balcony is going to result in issues for the unit. If that was the full story, I agree with you that there might be some liability for Lenox Green because it moves slowly in addressing this, but not an ongoing, as in continuing nuisance, because now everyone knows the fix is to regrade the balcony, and that is a unit owner. And so if you're not mitigating your damages, don't be going to American Family or Lenox Green. But now the roof is in the mix. And so we've got mixed causation of, is it precipitation cascading off the roof onto the balcony? Well, but the balcony sloped the wrong way. And so how do we work through that? But as long as the problem with water coming from the roof isn't remedied, it does seem like there's an ongoing liability that could accrue to Lenox Green because it hasn't fix that. And it does have the obligation to address it. And maybe it's with awnings that I'm hearing now for the first time are popping up in other units, but the poor 4 units here have not received the awning love from Lenox Green.
And potentially, I agree with the court as to the general proposition. I think it's impossible right now to know exactly what the claim is about the roof. And if there certainly is a circumstance in which the water coming off the roof was just water coming off the roof, but be that as may, and that's not for the court to decide here today. But I think if you look at the allegations in the amended complaint, there is still that aspect of there was an obligation for us to maintain the patio. What I heard Mr. Zim say was somehow that we had to get out there with a squeegee every time, which I think functionally ends up being at the same place. So I just wanted to point that out. This notion that nothing has been done, we can quibble about what's been done and whether more should have been done on the roof by now. That's an issue for another day. But I'll tell you, something has been done, and the reason I know something's been done is that the Lenox Green is suing the plaintiffs on a counterclaim for unpaid assessments. Now, that's not something I'm representing Lenox Green on, but that is a lawsuit that's pending. So something has been done.
It's a counterclaim in this case, or
Yes.
okay.
Yes. And Lenox Green's other counsel, because it didn't bear on the issues here today until just a moment ago. The other counsel did not come, but there is another counsel because we would be conflicted out. And then as to the punitive damages, number one, the other awnings issue is not pleaded in any of the pleadings. So I'm not sure, counsel saying that is not evidence, but what's pled is negligence and breach of contract. Punitive damages is not supported by breach of contract, and it's not supported by simple negligence. And here, what it sounds like is being argued is that Lenox Green was negligent. No, really, they were negligent. I mean, they kept being negligent. Setting aside whether, this is a dispute that should have been resolved prior to now, that is not willful and wanton and malicious, and there's no evidence about not placing awnings because of this litigation. Again, I think at best, without conceding liability, it would be a 13-611 issue, not a punitive damage issue.
Okay.
Thank you.
Thank you. Let's talk about scheduling. Assume that only some or none of the claims are dismissed or summary judgment granted for a defendant, so that we've got something that's moving forward. You all haven't engaged in any discovery yet because we had an extended stay because of the motion to dismiss. I will get this addressed soon, maybe with the help of one or more of you by helping draft an order, depending on what I decide. But if part of the case remains, I'd love to get a scheduling order in place that gets the case moving along. So let me start with the plaintiffs. Mr. Kaufman or Mr. Zim, how much time do you think you'd need for discovery?
Maybe 3 or 4 months. There may be an issue of competing experts, and that aspect may extend out. Fact discovery, I don't think should be that long. It's if we need to have engineers or hydro engineers or roofing guy, that's where it gets a little complicated. Also, depending on what the court does, we may ask for if it drops maybe the insurance party, depending on what the court does. We may be, ask for a certificate of immediate review before we continued on so far down the path. Obviously, I don't know what the court will do, but I certainly wouldn't waive that ability to do that, which may impact, because at that point I don't see having it too trapped, depending on what the appellate court does.
Okay. Well, assuming the case is going forward, regardless of my rulings and a request for a certificate of review, it sounds like 6 months may make more sense. Because when I say discovery, I am contemplating both fact and expert. And I'm happy for the order to have it broken out more if that's important to the two sides. That fact discovery closes at this date and experts disclosed on this date. My preference is just to say you got to be done with everything on the discovery side by date X. And I'll figure out what 6 months from now is in a little bit. do you think 6 months encompasses both fact discovery and expert discovery
Yes, Your Honor.
for plaintiff?
I don't see any reason why it would take, longer.
Okay, Mr. Stacy, since you're still going to be in the mix, we don't know about Mr. Wooten, but you're still going to be in the mix. How much time do you think you need for discovery?
I think 6 months is fine.
Okay.
I don't necessarily think that we have to have separate demarcation on fact and expert, but I would like some expert disclosure deadlines so that we're not getting disclosures right at the end. And
Sure.
I'm sure Alex will feel the same way.
Okay, yep.
Okay, Mr. Stacy.
Month 4. All right, Mr. Wooten, any reason to disagree with any of that?
I do not disagree at all, Your Honor.
Okay, all right, I can take it from there. Mr. Kaufman, anything else on behalf of your clients?
I don't believe so, Your Honor. I think we're good.
Okay. Mr. Wooten, anything else on behalf of American Family?
No, Your Honor.
Mr. Stacy, on behalf of Lenox Green.
There you are.
Do you know what firm represents Lenox Green for the counterclaim?
Yeah, it is,
It's not critical if you don't know.
oh, give me a moment here. The name is escaping me. It's Beth Taylor with Winter Capriola.
Okay, that's a firm that would handle something like that. Okay, but there are no pending motions concerning the counterclaims, right, at this point? Good, okay. Then I think we're done and we can close the record. I am going to, one other thing here.